Well, welcome. My name is James McConkey. I am a commercial and intellectual property litigator at the law firm of Workman Neidiger based here in Salt Lake City. And I am an undergraduate of this good institution, and I'm excited to be back on campus today, particularly given the excitement surrounding the university and what's going to happen on Friday night. Go Utes, we hope they win, right? I sit as a member of the executive committee of the litigation section of the Utah State Bar, and we're fortunate today to have Heather Snedden with us. She's one of our panelists. She's currently the president of that section of the Utah State Bar. That's the group and organization that is sponsoring today's event and that's brought in this good panel for you to learn about litigation from, and that paid for your food. So we're happy that you're enjoying it. And it looks like it's tasty, and we'll hopefully get some when this is all over with. Let me tell you a little bit about the litigation section and what we do. And Heather, if you want to add anything when I'm done, you're more than welcome to. The litigation section is a part of the bar organization that people can join. Once you pass the bar exam and you become a member of the bar, there are different sections of the bar that advance and support practitioners, legal practitioners in their work. The litigation section obviously works with folks who are in court and involved in dispute resolution. And there are people from a broad spectrum of backgrounds in that group, and we've tried to recreate that to some extent with this panel today. The litigation section organizes continuing legal education opportunities for members of its section and members of the bar at large, and otherwise works to support litigators in their work. One thing, for example, that they do to support them is they prepare what are called bench books. Bench books are information about different judges who sit on the judicial bench here in the state of Utah, how they like to do things in their courtroom, what are their likes and their dislikes. And that is a very helpful resource for folks who are appearing in front of judges on a regular basis. That's a little bit about the litigation section. We hope that when you graduate and as you pass the bar and as you become involved in your full-time practice, that particularly if you're involved in litigation, that you'll get involved with our section and begin to take advantage of some of the benefits that are associated with the litigation section of the Utah State Bar. So that's who's sponsoring today's event. Heather, would you add anything to that? Anything that you want to add?
I think you pretty well covered it.
Okay, good. Let me introduce our panel. And the idea today is that I have some questions that I'll put to these good folks about their day-to-day practice, what it means to be a litigator. I remember, just by way of background, that when I was in law school, the big question when I was a first year was, are you interested in transactional work or litigation? Those are kind of the two broad categories. And what ends up happening, I think, is that during that first year and often into the second year and sometimes into your third year, those are sort of general concepts, litigation and transactional work, but it's really unclear what that actually means in terms of your day-to-day. You're taking civil procedure, so you're learning a little bit about how courts are supposed to function, the rules that govern the process of litigation. But in terms of what that actually means to be a litigator, our intent and our hope today is that we can both share some insight with you as to what it means, number one, and then number two, if you have any other questions, you can certainly put them to us as a panel. The members of our panel have graciously made time to be with us today. I'll start by introducing Jared Hales. Jared is an attorney here in Salt Lake City who specializes in domestic work, meaning that he does family-related litigation, divorces, adoptions, custody matters, and the like. We'll have him talk a little bit more about his practice. He is a graduate of the University of Utah Law School, so he is an alum of this good institution. Heather Snedden is also a graduate of the University of Utah Law School. She is currently the president of Anderson and Carenberg, a very well-respected commercial, primarily litigation firm, and she'll speak to that experience, the experience of a commercial litigator, someone who's representing clients who are involved in primarily business and other related disputes. And our last panelist is Steve Anderson. I've known Steve for a number of years. Steve is a criminal defense attorney here in Salt Lake at the firm of Schatz and Anderson, and primarily does DUI defense work, although he does other criminal defense work as well. He studied law in Michigan at Michigan State, right, Steve? And so we're grateful to have these panelists with us. I thought that the first thing we could do is put the question to them: if you met a law student who was considering litigation and transactional career paths, and you had to say to them, this is litigation, how would you do it? We'll just work down the line to start with. Jared, do you want to begin?
No, sure. So the way I would kind of distinguish transactional from litigation is transactional is everything leading up to try to avoid litigation, and litigation happens after a problem has occurred. And so in litigation, a lot of times we think, maybe what we've seen on TV, on various different legal shows of going to court, arguing, having a jury there, talking to the judge. There's a whole lot that goes on behind the scenes before you ever get to that point. From the very first time a client comes in to meet with you and says, hey, look, I think I'm going to have this problem with this other party, and what do we need to do? All the way through filing pleadings, alternative dispute resolution, negotiations, exchanging evidence, to the point where you actually get to a trial and are in front of the judge.
Heather, anything that you would add to that?
Yeah, and I've done only a little bit of transactional work, and so I don't have a lot to compare it to in terms of litigation. But I think, my experience of litigation is that it can often be a little bit of a roller coaster. There are times when you have cases that are absolutely all-consuming, all day, all night, and you're getting prepared for trial, and that's all you do. You live and breathe your job. And then there are other times when it sort of calms down, you finish your trial, and maybe your other cases don't have too much going on, and you can kick back a little bit. Maybe you take time off work, you take the vacation you've been putting off, you don't come into the office for a few days or a week or so. And so there's a bit of a flow to litigation that's like that, that I think you have to develop a comfort level with and develop sort of a lifestyle around, because it can be like that a little bit. But I think Jared made a good point that a lot of litigation, I think, that can be surprising for you if you haven't done it yet, is that so much of it, I would say the vast majority of it, happens outside of the courtroom. And so it's working with clients, it's a heavy drafting type of job. Particularly in your early years, heavy research, document review, depositions, all of that stuff. And only a small pieces are in front of the court, especially like heavy civil litigation of motion practice and trial advocacy. And so even though those are really critical skills to develop as being an advocate on your feet, you also have to learn to be an advocate in writing and develop those skills, because that will be a big piece of what you do as a litigator.
Steve, before you answer that question, if there's anything you want to add, absolutely, but maybe this is a good point for us to transition into the litigation experience in your individual practice areas, because I think my guess is that you spend probably more time in court than anyone else on this panel, and perhaps do less in terms of the drafting side. And maybe you could talk about what litigation means in the criminal context.
Absolutely, and I think that's a true statement. I kind of picked up on something that Jared was saying. He was saying that part of his practice is that before maybe even getting into a courtroom, trying to avoid a problem. In a criminal defense context, the problem has already occurred, and generally the problem is a police officer putting handcuffs on my client and taking him to jail. And so there's not a lot as an attorney that I can do because I'm not in that part of the process. And so the problem has occurred. And in the vast majority of those types of situations where I'm engaged in a case, it's gone farther where a prosecuting agency Generally, a state or a city prosecutor has viewed whatever the allegations are against my client and decided to file criminal charges. And the way those are dealt with is in court. So on a day-to-day basis, I spend a vast majority of my time in court now. So that's dealing with prosecutors, and I think anybody, whether you're a prosecutor or a defense, private or public defender, you have to be well acclimated to the court system and to how it functions on the criminal side of it. There's a rare day that goes by where I'm not in court somewhere, and often I'm in multiple places, either in the morning and then in the afternoon. Trial practice is very heavy. I'm in front of a jury probably every 4 to 6 weeks. And so that takes up a vast amount of time. I'm not sure I know what transactional law is, to tell you the truth. It's not something I can speak to. But on the criminal defense side of it, on a day-to-day basis, in court, justice or district courts, and sometimes the federal courts, we're there on a daily basis. So.
Can I just add one thing?
Yeah, please, go right ahead.
One thing I was going to add is very much opposed to your practice. In commercial civil litigation, which is what I do, and particularly the bigger cases, which are the ones you end up working on because otherwise your clients can't afford to pay you to fight over this stuff. Trials just don't happen that often. And so if you're excited about a heavy sort of courtroom experience and career, it's not as heavy as you might think doing what I do. You'll be in court a fair amount doing motion practice and other things like that, but in terms of cases that go to trial, they just do not go to trial that often, in my experience. And so until you're, someone who becomes in your late years kind of the trial person in your firm who gets handed the trials to do, and you're someone who's still working the cases on a day-to-day basis, it's much more likely that you might be doing one trial a year, if that.
Heather, you actually anticipated my question.
Oh, sorry.
No, you're totally fine. I was going to come to you next and say, litigation, I'm a commercial litigator as well, and my experience is that I do a lot more writing than I do oral advocacy. I was in court this morning on a motion for summary judgment, but that was something that discovery, depositions, and the like all build up to. Mm-hmm. People often use the phrase motion practice. Can you help the students understand what that means? What is a motion practice? We understand kind of where Steve is coming from in terms of arguing, being in court, trying things, but in commercial litigation, we talk about a motions practice. What does that mean?
Sure. Let me see if I can describe that. Cases have a certain trajectory in civil cases. So after a complaint is filed, for example, if you represent the defendant, your next stage of the case is, well, are you going to file an answer to that complaint, or you're going to file a motion to try to dismiss the complaint? So that's one opportunity for motion practice where, as the defense counsel, you may be deciding, I'm going to draft a motion to dismiss on whatever basis you might have. The other side has a chance to oppose it. You file your reply memorandum. All of that is a significant undertaking in legal research and writing. And depending on the nature of the motion, it could be a huge motion. And then you get to, if you get past the motion to dismiss phase and the case is proceeding, then you get into the discovery phase of the case, which is the longest phase. You're doing, document requests that you have to draft. You're reviewing documents that are produced to you. You have to prepare initial disclosures. You're preparing for depositions. A lot of that is in your office, looking at documents, doing the research to figure out your claims and your defenses, and evaluating, how you're going to proceed with getting the information you need in your case. Maybe I'm telling you guys stuff you already know, so I apologize. So in the discovery phase, there may be some motion practice around whether or not, the other side is producing to you the documents you think you're entitled to that you've requested, whether or not their witness has answered the questions they're supposed to answer in their deposition, and you may fight over that, and you're filing motions, or depending on which court you're in now, short form discovery motions, or you're filing other things like that have a much more condensed time frame now. And then if you get through the discovery phase, you're then in the phase of filing dispositive motions, usually summary judgment motions, if you think that you can establish that There are no genuine issues of material fact, and you're entitled to judgment as a matter of law. That's the standard. So summary judgment motions, which is what James just did, are usually significant in my practice. You're relying on all of this fact discovery you just did, deposition testimony, documents. You're having to gather all the evidence together and present it to the court, go through the claims that are at issue and establish either these claims I'm entitled to judgment on, or I'm entitled to, win on my defense to those claims based on all of this evidence. And so the preparation of a summary judgment motion in particular, and motions to dismiss too, but summary judgment motions is enormous. It's a lot of legal research and a lot of drafting and many drafts. And then you're working with your clients on declarations and affidavits, and your client might be inclined to say, yeah, that all looks pretty good, and I'm just going to sign on the dotted line. But it turns out that some of the stuff in there is not quite right, and you have to really make sure they're reading it carefully. And so it's a lot of work in the drafting phase. And then you file those, and then, it's a prep for the argument, which is also significant. But your time in front of the court, in front of the judge on that motion, if you're in state court, maybe you'll get an hour, maybe you'll get a half an hour, compared to the dozens of hours that went into the preparation of the motion. So that's probably a longer explanation than you need. But with motion practice, there's so much more work in the drafting than there is in the oral advocacy piece of it.
Yeah, I think motion practice is about gathering evidence and putting written argument together that you then get to put forward in terms of an oral argument for maybe, like you say, an hour. I was in front of the court for an hour this morning. You also talked about depositions. You all know what those are. Those are sworn testimony in the evidence gathering phase of a civil case. Steve, you don't do depositions, do you?
We do not.
Yeah. So on the criminal side of things, you don't see that. If they're getting a witness, they're typically getting a witness on the stand. Let's contrast that a little bit with a domestic litigation practice, because I'm guessing that you probably, in some ways, are a hybrid of the experience that Heather's described and the experience that Steve's described.
Sure. So we're kind of the outlier in the legal process. So in domestic cases in Utah, at least in northern Utah, in the more populous areas, our motion practice is actually in front of court commissioners who are judicial officers, but they just handle all the preliminary matters up to trial in domestic and family law cases. And so when I get a new client that comes in that wants to file for divorce, we'll file our petition for divorce. And since that can take a while to either settlement or trial, a lot of times they'll need some temporary orders in place for custody and parent time, alimony, child support, those things. So we'll file a motion for temporary orders, and we'll go in front of one of these commissioners and have a hearing. It's done by proffer, so clients actually don't get up and testify. The attorneys speak for the clients. And one distinction that may not be clear to some is that in a motion practice, when we're talking about arguing these motions, it's in front of a commissioner in domestic practice or a judge in the other practices without a jury, just to the judicial officer only. So we deal with the commissioners a lot. The commissioner then makes a recommendation based on what they're seeing, which the judge signs off on. Although the parties still have an opportunity to go in front of a judge or to argue to a judge that the commissioner got it wrong if they want to. So it's a little bit different in family law as far as those rules go. And then also, ultimately, if you end up at trial, we don't have juries in family law cases. It's always done in front of a judge. So, but I would agree with Heather, at least in my practice, I go to trial once or maybe twice a year. It's really rare. It seems like a lot of the fight now is done over email with attorneys. Even outside of filing briefs or motions with the court, it's a lot of arguing going back and forth in email. I cannot stress to you enough the volume of email that we have to deal with. I'll probably, if I had my phone on, it'd just be going bing, bing, bing. So, yeah.
Good. Let's do this. Starting again with you, Jared, and working back this direction. identify a trait that you think is important for a successful litigator. And then, if you would, recommend to the students here some class or activity that they can get involved in while they're still in law school that will either help them develop that trait or to become a successful litigator if that's the path they choose.
Okay.
So one characteristic for a successful litigator, and then something that they should be doing now to prepare.
So I would say if I was to pick one characteristic that I think is helpful, at least in my litigation practice, is being able to have objectivity with your client. Especially in my area of law, as you imagine, people come in, it's a highly emotionally charged area. People are mad at what their spouse did or what they didn't do, and they're out for what they think is fair justice, and getting emotionally caught up in that and not being able to see, okay, look, this is how a judge may look at this, makes the case a lot more difficult. I deal with attorneys all the time that are just, really, really upset at how my clients treated their client, but they haven't heard the whole story yet. And sometimes that has a negative effect on clients where they only get more raged, and getting to a point of settlement is that much more difficult. If I was to say there was a class or a program I participated in law school that helped me in my litigation practice, it would probably have to be, I did a judicial internship for a third district judge named Robert Hilder. He's since passed away. But I was able to go and observe trials, hearings on motions, and just being able to go and see how he approached it, seeing how different attorneys argued, what seemed to be effective, what seemed to not be effective. Still to this day, I think back about different styles I saw and try to incorporate that into my own litigation practice. So that was really helpful to me.
I think that's great advice. I worked for a judge as well while I was in law school, Christine Durham, who used to be the Chief Justice up at the Utah Supreme Court. And probably the summer that I worked with her, learned more about what it really meant to be involved in an appellate litigation practice and what was effective written advocacy than in anything I did while I was in law school. So I would endorse that as a great recommendation for developing litigation skills. Heather, one skill and then something they could do in law school to develop.
The skill I was thinking of is sort of finding your voice and your confidence, because it's important, particularly, it's easier if you're just drafting all the time and you can sort of be in your office and you don't have to interact with people, or maybe not many people. But if you're going to stand up in a courtroom and try to convince the judge of your position, you have to exude some confidence about what you're saying. And you have to figure out what your style is and what your voice is in order to do that. And one of the mentors in my firm has always said that the practice of law is a con game, meaning you have to have confidence to sort of convince someone of what you're saying. And sometimes you have to exude that confidence even before you have it. And so thinking about that just in terms of oral advocacy, and trying to figure out how you're going to be the one that's persuasive up there. The other thing, and in terms of trying to develop that skill and classes and other experiences, I think that help. One is just preparing more than the next person in terms of having confidence when you're standing up in a courtroom. And if you don't understand the process very well or how it's going to go, that's going to affect your confidence. So you want to make sure that you're learning how this is going to go. And maybe it's sitting in front of that judge's, or sitting in that judge's chambers, or in their courtroom rather, to see how they handle hearings and how to expect how your hearing might go. Maybe you have to go over a couple weeks early and watch. And so things like that, but more specifically in terms of, classes that I took at the U, I think you had maybe asked about just in your email to me. Trial advocacy, if you want to do litigation, is incredibly useful in terms of understanding how trials work, what you can expect, and gaining some confidence in developing those skills that you need. I also took a class called Advanced Torts, which was preparing all of sort of the pleadings and discovery and stuff that is in a case, so you have more familiarity with the process. And then I have to also endorse what Jared was saying. I also interned with a judge, Judge Peeler, who is now retired. And that was an eye-opening experience of just watching other lawyers do what I wanted to do and seeing what works and what doesn't work and being able to bounce those ideas off of a judge who is also, you know, getting that same input from lawyers that they're hearing from. And also, there's also a piece of it of like, you know, some lawyers don't do the best job. And so when you're sitting there watching them, you're like, I can do this. I can do what that person just did. And that makes you feel a little bit better about like, you might be the new person who's coming to the courtroom, may not be as familiar with it as the lawyer you're up against, but that you can still do it and be successful.
My brother's a lawyer as well, and he tried a case a year or so ago, and he called me after the case. I probably shouldn't tell this story, but he called me after the case was over, and there was a pretty well-known lawyer on the other side, and he finished, and he got out, and he goes, I'm not that bad, right? Like, he compared himself to this really, a high reputation guy, and he was like, I'm pretty good at this, So I think you can find confidence in watching other people because it takes some of the fear factor away, don't you think? Mm-hmm. I think that's really, really good advice. Steve?
What I'm about to say adds to what they have said because those are very good points. I would say on a day-to-day basis, as I hear what I complain about or what my partner or other people that do in criminal defense work, a skill and something that we struggle with, it's managing client expectations, and that may seem like a kind of a vague thing, but I think if there's anyone here in the audience who's thinking about participating in criminal work, you probably know who you are. Be prepared to deal with potentially some difficult people. So you have to wear that hat. So if you have strong social skills, or maybe you lack in that area, that may be something to take a look at because a lot of my time is managing expectations and managing my clients, what they think is going to be happening in court. And so on top of what they have said. And then I would echo, I think I've had a very similar experience as the other three. Although I didn't go to school here in Utah, I was in school in Michigan. I clerked for a judge. And it was a trial judge, and I spent time and I learned quite a bit. The one thing that, on top of that, I know that the U has, although I didn't go to school here, I know as a part of the criminal, there's a program here that is tailored for those folks that are thinking about doing a criminal practice. There's placements in the public defender's office. There's also placement, you can do internships for the district attorney's office or Salt Lake City prosecutor's office. There is no substitute for actually stepping foot in a courtroom and participating and seeing if this is something that you're into, or on the flip side, you may say, look, this is not what I want to spend my time doing. And that answers a big question as well. And so those are the things I'd be somewhat thinking about.
I just want to add something real quick to what Steve said about managing clients' expectations. Something I was kind of surprised to find out as I started practicing was some of my biggest arguments, and when I had to be the most convincing, was with my own clients. Because the client's mom that comes in with them, the client's neighbor that's told them, oh, my brother was in the same exact situation and here's what they got. Of course, not really being in the same situation, but being able to manage the client's expectations. That's a great point.
Mm-hmm.
I would just add this from a commercial standpoint. I don't know if I'll be curious to see if you agree with me, Heather, on this one, but I often represent corporate clients and I'm working with their general counsel, who's a lawyer and who has experience with litigation, managing litigation that a company's involved in all over the United States. And I think this idea of finding your voice and even managing client expectations with the sophisticated legal consumer is an important skill for a litigator. And what that requires is that you are always straight with, you have the confidence to be straight with your client. Because sometimes they're going to call you up and they're going to say, that blankety blank so-and-so, did X or Y and didn't live up to their obligation, or, did this, that, or the other that was so damaging to our business. I want to go after them for everything they're worth. And you have to honestly evaluate that case and report back to your general counsel or whoever the corporate representative is that you're working with. And sometimes you have to say, this is not a good case and it will be a waste of your time if you go forward. And that's a hard conversation to have sometimes with a person who is going to say, hey, I went to law school and I've managed these cases for years and years and years, and I want this outcome. And I think you have to develop the confidence to be able to speak honestly about the value, probability of success, etc., of any case that comes to you from a client. I don't know if you agree with that.
I totally agree. I have a lot of clients who are, own small businesses or medium-sized businesses, whatever. So you're working with the CEO or whoever's been sort of assigned to handle this particular litigation. And then also I have some clients who the client contact is the general counsel, but it's very much like James is saying, that it's a different type of rapport that you have to develop with a general counsel who has the same or similar, at least, legal education that you have. And so there's sophistication in talking to you about strategy in a case and wanting a detailed litigation budget and all of these types of things is on a different level. And you have to be, like you said, almost even more persuasive in those situations because you have someone on the other side who speaks your language. And I think it's important, like you said.
Advocacy on every level is really what litigation is about. If you summarize it, it's about advocacy in almost everything that you do. One of the things that's always interesting about careers in general, but particularly so about legal careers, is how a person ended up doing what they do. And I wonder, Steve, if we started with you, how did you end up doing criminal law? What took you there? What drew you to it? And a little bit about your professional story.
Well, I've always been drawn to the criminal justice system. I did my undergraduate, my bachelor's degree is in criminal justice. Generally, a person with that type of degree is either going to go into law enforcement as a peace officer or work for adult probation or parole or do something like that. My interest was high in the field, but I did not want to do that particular thing. So I ended up going to law school, and when I finished back east, I came here back to Salt Lake, where I'm from. And to tell you the truth, I had 2 job offers at the time. This is the late 90s. I had a job offer to work for the Olympic Committee. At the time, the Olympics were coming, and it was going to be a great job. It was in the civil, enforcing trademarks, and it was going to be a great job. But they made it very clear that the day this flame went out up here at Rice Eccles, you're out of a job. And so I wasn't really happy about that. And so I found myself working for a solo practitioner who did this particular type of work. And it rekindled my interest in the criminal justice system, and as I marched forward with it, it really turned out to be the correct path. And so it wasn't so much, it's a little bit of a happenstance, but it turned out to be the right path. And so it's been me and my partner, the Schatz and Anderson, we're almost approaching 20 years of doing this, which is quite amazing. And awesome. And it's been a good path, so.
Heather, I'm going to skip you and come back because I have another question I want to put to you in just a second. What was your path to a domestic litigation practice?
So I didn't really know what area of law I wanted to go into, but when I was doing that judicial internship with Judge Hilder, he was covering the Park City calendar, and he had this trial for this couple where the husband had made, it was like $90 million flipping a regional railroad in Illinois. And so they were having this divorce trial, and it was fascinating. I mean, they were talking about their $20 million house in Maui and how much they paid in expenses every month up at their house in Deer Valley, it was like 30 grand a month for utilities and upkeep and all those kinds of things. And I thought, this is kind of interesting. It touches on a lot of different areas. It touched on property and tax and the implications on their divorce. And so that was my second year of law school, and I started sending my resume out to a bunch of smaller law firms that handled family law cases, and one of them made it past the shredder, and I got a clerkship with this little small 5-attorney law firm that did family law and a little bit of criminal defense, and it was all women. I joked around with them that I was kind of their token male in the firm. So I ended up working with them, worked with them after law school, and it was just fantastic training. Got to do a lot, got my own cases right away. Was able to go to court quite a bit and kind of start practicing in all aspects of that. But their model was not that you became a partner in that law firm. It was, you're an associate, you can make some money here, but you'll never have any kind of ownership. And so I ended up leaving there to go to a bigger firm, actually to practice with James' brother. And from there went to a couple different firms, ended up at Parsons, Bailey, and Latimer, which is one of the bigger firms in Salt Lake, helping to start a family law practice there. And from there, just kind of had enough people referring clients to me that I ended up leaving and opening up my own law firm. And so it's always interesting to me. I mean, frankly, I was not a law review law student. Ending up at Parsons, I think there were 6 or 7 of us from my graduating class here. 2 of them have become judges in the last year. And I would always tease them saying, "Oh, you guys work so much harder in law school," and here I am at the same firm. But I ended up in an area where practicing in an area that there was opportunities for, and there were opportunities to go and get your own cases right away. And I hope not. I hope nobody grows up thinking I want to be a divorce lawyer. But here I am. So, yep.
Can I just? When I was in law school, I remember the first semester we got grades, and back then we didn't get grades online. We got grades over the phone, and so I know that sounds funny, but I remember sitting in the law school, and all of a sudden there was this rumor, grades are out. And so there was this rush to the payphones because no one had really cell phones at the time. I was in law school in the late 90s. And so there was this line at the payphone so that everybody could dial in and, hit 7 if you want your grades and 8 if you want to know how much you owe us for tuition. And there was a bank of 3 phones, and I was in the middle, and I had 2 people next to me. And we were all getting our grades at the same time, and I got my grades, and I was like, okay, it's not what I'm used to, but I can survive. The person next to me just starts pumping their fist, and the person on the other side of me just bursts into tears and runs out of the law school. And I realized, that the further you get in your education, the more intense the competition. But what you have indicated is, I think, an important thing for people to remember, which is, if you continue to work hard and hone your craft, law school is not the determining factor in how successful you can be in your career. That's an important thing to remember. Standing at that bank of phones, I think this person thought, I'm going to be a Supreme Court justice. I thought I might be able to get a job. And the other guy thought, I'm going to have to declare bankruptcy because I've now got student loans that I can't deal with, and I don't know what I'm going to do. So I think I say that as an aside because I think that's a really important thing. Heather, if you tell us a little bit about your story, but you mentioned a word earlier on when you were kind of introducing what you do. You used the word mentor. Would you talk about the role that a mentor might play in the development of a litigation career and the importance? And I don't know whether a mentor has played a role in your story, but if so, maybe you could share that with us.
Sure. My story is, if I how much of this would be interesting? I sort of fell into going to law school. I didn't know what I wanted to do with the degree that I was getting in undergrad, and my best friend and college roommate was applying to law schools, and she's wicked smart. And she was returning to Texas, which is where she is from, applying to UT, and I was like never going to get into UT. And so I decided to apply to law school at the U, the one school I applied to, and I thought if I get in, I'll go, and if I don't, then I guess I'll work it out. And I got in, so I went. And I certainly did not know what I wanted to do once I was in law school with a career. But having some experiences in law school, including a judicial internship, as Jared had, and I also worked for the Securities and Exchange Commission, the Division of Enforcement, one summer. And that was really cool and eye-opening and frightening all at the same time, but very, civil enforcement, litigation focused. And then my final year in law school, taking trial advocacy, I think sort of solidified for me that my path was going to be more litigation focused as opposed to transactional. So that's what I tried to do getting out of law school. I first started out with just a solo practitioner who does insurance defense work. And nothing against her or that type of work. She had talked about it being, this very broad scope of types of cases, and I thought it sounded interesting. I worked there for a short time and decided it was not really for me. And so then I started looking for jobs and ended up finding one at Anderson and Carenberg, which is where I'm at now. I've been there for 15 years, almost 16 years. So I've been there a long time. So that's sort of my path and how I guess I got interested in litigation, and then it sort of just unfolded from there. In terms of mentors, a big mentor for me was Tom Carenberg, my former law partner, who's now basically retired. He's a well-known trial lawyer in town. And being able to work under him and sort of second chair trials with him and manage cases with him was an incredible and experience, and gave me a lot of insight into, how to be a better lawyer. But it was also sort of critical in a very more generic sense of just, having someone who's very experienced in the field that you're working in, that you can go to with what seem like ridiculous questions, but you're not going to know if you haven't been practicing long enough. And so having that relationship was important for me to be able to ask him questions about, okay, well, how is this going to go? I'm going to be in front of this judge. I don't know anything about them. And where do I stand? Do I stand up to introduce myself? Do I sit down? When do I go to the podium? When do I not go to the podium? I mean, stuff like that if you haven't appeared enough in court, seems so daunting because you just don't know them yet. But also the more difficult questions about am I on track with my career, and how do I get clients? How do I get my name out there? And someone who can champion you to help have that happen. Another mentor of mine actually is John Hafen, who is not at my firm, but is a lawyer at Parr Brown. And once I met him, encouraged me to get more involved with the Utah State Bar and the litigation section, to become an officer of the litigation section, to get involved in some other committees with the bar, which I now serve on another committee with the bar, and therefore get to meet other lawyers and practitioners who can become referral streams for you. Because once someone meets you in a certain capacity, and this is just, I think, human nature, if they think you're good at one thing, they think you're good at lots of things. And so if you do a good job serving on the litigation section, then maybe they say, oh, I know Heather, and she does this type of work, and she's great, and I'm going to send her this case. So that's great. So those types of things mentors can really help you with. So it's not just about learning how to practice law and be a good lawyer. It's about also developing your own book of business.
I have one last question for you as we start to wrap things up. Litigation, one of the things that may kind of scare people off is the sense that it is just adversarial all the time. I mean, there's times, frankly, when I come home, if I've been in a deposition all day long, or I've been on the phone with opposing counsel, or sometimes even my client, where I'll walk in the door and my family will know it's been one of those days. Because, my son will come up to me and say, did you see that LeBron dropped however many on, so-and-so? And I'll say, yeah, but and then we get into this argument about whether LeBron's a great basketball player or not, because my natural reaction is to just argue. It's not good. So what I wanted to ask was, for those who are maybe concerned about that adversarial nature and kind of bringing it home, how do you not let that kind of overwhelm your life and everything that you're doing? And we'll just start here and work down the line. Or is it
So
even possible?
No, it's possible.
Are you successful?
Yeah, right.
Maybe 80% of the time. But, so I have kind of two things. The first one I'll tell you, but I don't want you to let it leave this room. So when you go to court, you get it's such an adrenaline rush, but you have to sit there and be calm, listen to what's going on, trying to listen to your client talk to you while you're trying to hear everything going on. And so I found I'd get out of court and I have So I have this funny thing where on the way home from court, I have to listen to terrible gangster rap. I don't know what it is about it, but it just calms me down before I get home or back to the office. I don't know why. Probably don't do that. You can find something more effective. But then the other thing, just from a work-life balance, I mean, I've got a bunch of kids that have demanding schedules, and so I just have to find a couple hobbies that I can do, that I can spend money on and spend some time doing. Not that completely consumes my life, but it's something to look forward to. If there's, I've really gotten into hunting, and so if I have something coming up having to do with that, it's okay, I can get through this week because I know Friday I'm going to take off and go shoot pheasants or ducks or whatever. So having a hobby where you can do that. Don't worry about the love of gangster rap and the love of hunting. I'm cool. Don't worry about that, okay? But anyway, that's what I do.
Yeah, that's good. Heather.
I'm going to try the gangster rap.
Yeah, you try it. It works.
That was great. I won't lie, it's hard. Because litigation can be very adversarial. And a lot of times you'll have cases where you get along really well with opposing counsel and you're just proceeding through their case and you're representing your clients, but it doesn't feel like you're fighting all the time, and you're going to have other cases where it does. And trying to leave that at work all the time is challenging. I would say that maybe not the gangster rap piece, but similar strategies of planning that next vacation or things that you have to look forward to is helpful. And I think also for me, it's trying to allow yourself the chance to vent, whether it's to one of your law partners or it's to a friend or it's to your spouse or your romantic partner. If they kind of understand this part of your work, giving you a chance to just sort of about it and then just being done with it is helpful for me anyways. So my partner's gotten used to listening to me come home and sort of scream about the latest issue in a particularly contested case, and then I'm done with work for the night. And I can be better about letting it go. And another thing that I think about is a lot of the difficulty sometimes of setting that stuff aside is you're representing a client in a case that you are invested in. I mean, you're invested not only as a lawyer because you care about your work and your work product and stuff like that, but you care about the client that you're representing and the situation that they find themselves in. And so a lot of the anger and sometimes the rage that comes with that is because you've taken that on from your client because they have it. And you want the best outcome for them. And so you can't always let go of your mind chewing on this stuff at night. At least I can't. And so it sometimes also means the waking up at 3 a.m. and emailing your law partner about I thought of another argument for the motion we're filing tomorrow, and if I don't write it down right now, I'm just going to sit here and stew about it. And so you do that. So that happens sometimes too. But I mean, those are my best coping strategies.
You know, a lot of people are surprised when I tell them that in the criminal justice and criminal defense and prosecution system, as attorneys, we generally are very cordial with each other. I listen to some of my civil friends talk about how, frankly, how nasty it can get on from the counsel perspective. A lot of that just doesn't exist in the criminal justice world. It's not absent by any means. And the cases sometimes can be very personal and involved, and, you know, the outcomes can result in somebody potentially going to prison. I mean, so the stakes can be high, and so that kind of stuff weighs on you. And I'd echo what has been said. You want to do the best you can and be a vigorous advocate for your client, but you have to be comfortable, and it's a skill that you have to develop, that when you walk out of that door, you're leaving that at the office. If you're taking it home completely, and it's impossible to just to leave it all on your desk in the office, but if you're taking all of that home with you, I can tell you that you're going down a rabbit hole that is going to be kind of hard to get out of. I always try to remind myself, and what I'm about to tell you may seem odd from your perspective, because I'm sure in your mind you're thinking about, I got to pull the grades, I got to figure out who's going to hire and pay me to do a thing, and that I've dedicated, 3+ years, if not more, and so that's really forefront. But I would suggest to you that the law and being an attorney and a lawyer is only one thing you have decided to do in your life. There are other things. Now, be it hunting or what, gangster rap, whatever that is, remember that the practice of law and being a good litigator and being an advocate and being skilled and all those things, that's just one thing you've decided to do with your life. There has to be other things, because I think the problems and mental health issues and addiction issues that lawyers can kind of get themselves into is pretty high. And so be aware of those types of things. Our profession has a high proclivity for those types of ditches to fall into. So as you're planning your future and what you're going to do, have balance, have a quality of life as you're going to go and blaze the trail and be awesome attorneys that we all know you're going to be.
Point out one
Yeah,
more thing.
please go right ahead.
It took me a few years into my practice before it occurred to me that in litigation, like I said at the beginning, we're helping people kind of once a problem has started, realizing I can't go back and change the facts of what have happened in the past. I can't go back and change whatever my client's done, or, so I'm helping them kind of set themselves up for the future. But you just simply can't function if you take it on yourself that you're somehow responsible for what they've done in the past. That seemed to help relieve a lot of stress.
I don't listen to rap, but if I walk in the door and I'm seeming adversarial to my family, they say, go swimming. And that's kind of what I do. Everybody has their thing. I think you've gotten great advice today. We really appreciate you coming. We hope that those of you that choose to go the path of litigation and who become members of the Utah State Bar, please become a part of our section. We love the collegiality and the learning and the opportunities to better ourselves that come from being a part of that section. We're grateful to have had you with us today, and we appreciate your time. Thanks for coming. I know Steve's got to run, but the rest of us will be around for a little bit if you want to talk or if you have any specific questions. Thanks.